Good afternoon, dear colleagues. Thank you so much for attending this afternoon's panel with the title, Why the Slave Trades of the Past, Present, and Future Call for Rome Statute Rectification. My name is Alexandra Lilly-Cather. I'm the co-founder of the Emergent Justice Collective, which is a transnational collective of feminist activist scholars and lawyers. And we collaboratively pursue legal strategies, including legal intervention, to further structural change of oppressive systems at the root of global injustices. And we do so by centering intersectionality, community healing, and transformation in justice and accountability processes, let them be formal or informal. Sadia Hartman, who's a professor of English and comparative literature at Columbia University, notes in an interview published by the White Review, and I quote, "If you're really present, then what is undeniable is the devastation and loss and genocide. All the death and destruction for the purposes of capital accumulation. In this way, trade still structures our lives today. And in other words, we are living in the world created by the transatlantic slave trade. By the same token, if we look at the International Criminal Court, but also if we look at the investigations and prosecutions of international crimes currently ongoing at the domestic level under the principle of either universal jurisdiction or the principle of active personality, we see that courts really grapple with the legal characterization of the slave trade conduct having occurred contemporaneously in, for example, Libya, Iraq, Uganda, among others. On this note, it's my very honor this afternoon to introduce you to the speakers of this panel in the order of their respective interventions. All are international law experts working in diplomacy, legal practice, and academia. To my left is Ms. Hawanatu Kebe, who is the first secretary and legal advisor of the Permanent Mission of Sierra Leone to the United Nations. Her intervention will be followed by Professor Patricia Visser-Sellers, who serves as the Special Advisor for Slavery Crimes at the Office of the Prosecutor at the International Criminal Court, and she's also a visiting fellow at Kellogg College at Oxford University. Next is Payal Shah, who is the Director of the Sexual Violence in Conflict Program at Physicians for Human Rights, and Professor Jocelyn Getkin-Kessenbaum, who's Professor of Law at Cardozo Law. Before I give over to Ms. Kebe, kindly note that I will announce the code for the CLE credits that can be obtained for attending this panel at the very end. Turning over to you, Ms. Kebe, could you talk us through the proposal that is being put forward by Sierra Leone pertaining to the inclusion of the slave trade and slavery crimes?
I thank you, moderator, for giving me the floor. The permanent representative, Ambassador Kano, who could not be here this afternoon, sends his apologies as he had prior commitments and could not make it this afternoon. He has asked me to introduce the proposal by the delegation of Sierra Leone on the Rome Statute Slavery Amendment. Distinguished participants, allow me to extend my deep appreciation to the organizers and for your presence, signifying the importance attached to the inclusion of the slave trade in the Rome Statute in order to address a long-standing gap in the statute. This panel indeed offers a good opportunity to discuss the Republic of Sierra Leone's proposal to amend Articles 7 and 8 of the Rome Statute of the International Criminal Court, which has been introduced and circulated through the Working Group on Amendment of the ICC-ASP. What the delegation of Sierra Leone in New York has done is to circulate relevant documentation on the proposed amendment, and this includes: 1, a letter from His Excellency, Mr. Michael Iman Kanu, Permanent Representative of Sierra Leone to the United Nations, to the chair of the Working Group on Amendments, notifying the Working Group of the intention of the government of Sierra Leone to submit proposed amendments to Articles 7 and 8 of the Rome Statute. This was dated 4th May 2023. 2, annexed to the letter with the proposal for Rome Statute amendment, which was conveyed by the Permanent Mission of Sierra Leone to the Working Group on Amendment on 5th May 2023. And three, a non-paper for state parties to the Rome Statute of the International Criminal Court on slavery and slave trade crimes. Since the annex with the proposed amendments and the non-paper has been previously circulated and I believe is available publicly, what I intend to do today is to briefly outline the motivation and importance of the issue to Sierra Leone firstly, and then to proceed to talk about the proposed amendments to introduce the main idea to the symposium. As may be gleaned from the documentation, Sierra Leone took steps to notify the working group on amendment on the amendment proposal in line with paragraph 7 of the terms of reference governing the work of the working group on amendment. This was to ensure broad and inclusive discussions before the formal notification is submitted to United Nations Secretary General. In examining the process generally, we have been guided by the provisions of the Rome Statute and the resolutions of the Assembly of State Parties. Article 121, paragraph 1, requires that a state party proposing an amendment may do so, and the text of any proposed amendment be submitted to the Secretary General of the United Nations, who shall promptly circulate it to all state parties. Paragraph 2 provides that no sooner than 3 months from the date of notification, the Assembly of State Parties at its next meeting shall, by a majority of those present and voting, decide whether to take up the proposal. The Assembly may deal with the proposal directly or convene a review conference if the issue involves so warrants. As some may know, by Assembly Resolution ICC ASP/8/6 in paragraph 4, the working group on amendments was established for the purpose of considering amendment to the Rome Statute proposed in accordance with Article 121, paragraph 1 of the statute. It is therefore in this working group discussions in line with Article 121, paragraph 1 of the statute will take place, mindful of encouragement to do so as contained in paragraph 7 of the terms of reference governing its work. Now I will address the issue of why it is important for Sierra Leone to propose amendments to the Rome Statute. Let me offer 2 fundamental points on why Sierra Leone has proposed amendment to the Rome Statute to include 1, the slave trade as Article 7, 1C as a crime against humanity. 2, the war crime of slavery as Article 82B 28 during an international armed conflict. And 3, the war crime of the slave trade as Article 82B 28 during an international armed conflict. For the war crime of slavery as Article 82E during a non-international armed conflict, and the war crime of the slave trade as Article 82E during a non-international armed conflict. The first point is the historical nexus. Sierra Leone and Liberia were the sites for the repatriation of the freed slaves at the abolition of the transatlantic slave trade. Uniquely, Sierra Leone was described to have been at the confluence of several migratory movements. It was a place of departure, a place of return, a place of exile, and a place of refuge, the province of freedom. The government of Sierra Leone therefore places high value on the historical nexus to the slave trade issue. The second point relates to our principal commitment to ensure accountability for international crimes, including the core crimes of genocide, war crimes, and crimes against humanity. Our recent transitional justice history has consolidated the constitutional foreign policy to pursue and ensure accountability for atrocity crimes. The Special Court for Sierra Leone, created by treaty between the United Nations and the government of Sierra Leone in 2002, on the request of the government of Sierra Leone, and authorized by the UN Security Council, Resolution 1315, was established with a view to address impunity, following widespread atrocities perpetrated during the protracted civil conflict which ended over 2 decades ago in Sierra Leone, and to ensure that those who bore the greatest responsibility were brought to justice. There was justice for victims as the Special Court for Sierra Leone, which had many firsts in terms of the novel jurisprudential contributions to the development of nascent international criminal law and justice, was the first international tribunal to recognize the new crime against humanity of forced marriage as an other inhumane act. This significant new legal approach in the investigation, prosecution, and conviction of individuals for forced marriage as a gender-related violation of international criminal law is a legal legacy of the Special Court, which is also of high value Sierra Leone and one we pursue at the global level. The transfer of the so-called bushwives in that context was slave trade. Similarly, the enlistment of child soldiers and their transfer for one fighter faction to the next was slave trade in our context and slave trade in the current global context. Regrettably, the Rome Statute does not contain provisions for the slave trade as a crime against humanity or as a war crime. Specifically, Article 7 of the Rome Statute omits the slave trade as a crime against humanity. Article 8 of the Rome Statute omits provision for the slave trade as war crime in international armed conflict and in non-international armed conflict. The Rome Statute's legal omissions presently result in significant impunity gaps. For example, the migrant held until money is paid for their release, or the teenage boy abducted in a militia and transferred among units in which he is forced to fight has been slave traded. Also, the so-called bushwife, who is distributed to one fighter and then redistributed to another fighter, has been subjected to repeated acts of the slave trade and slavery. The purpose of the proposed amendment is to close the identified legal gaps for slavery and slave trade crimes under the Rome Statute. The legal basis for slave trade and for slavery and slave trade are firmly established in international law. However, given the omission, the Rome Statute does not allow for perpetrators to be held accountable for acts of slavery and slave trade crimes in all contexts. The Rome Statute does not have jurisdiction over the slave trade when committed as part of a widespread and systematic attack against the civilian population under crimes against humanity. Similarly, the Rome Statute jurisdiction does not include acts of slavery or the slave trade as war crimes during periods of armed conflict. The present legal omissions in the Rome Statute, as said, result in significant impunity gaps. Consequently, under the Rome Statute, survivors of slavery and slave trade crimes are denied comprehensive acknowledgement of and redress for their harms. Slavery and the slave trade are jus cogens norms, rooted in both treaty and customary international law. They apply under all circumstances, including in international and non-international armed conflict. Respectively, the slave trade and slavery should be explicitly enumerated in the Rome Statute under crimes against humanity and war crimes, and this will send a strong signal to the victims. It is significant that we are having this discussion as we celebrate the 25th anniversary of the adoption of the Rome Statute. Let us continue to deliver on the promise of the Rome Statute by closing the impunity gap on the slavery and slave crimes. I thank you.
Thank you so very much for not only providing an overview of what the proposal is contained of, but also for your reasons of putting this proposal forward. Now, we've heard you mentioning the gap both under war crimes, but also crimes against humanity under the Rome Statute. And for the rest of the discussion, we really would like to hone in on both the legal gaps, but also what these gaps mean in practice. Most of all, of course, for the persons concerned and subjected to these crimes. With this in mind, I turn over to Professor Risser-Sellers. And if we look at the Rome Statute and specifically under war crimes, what is the legal lacuna we are seeing? And what consequently is the lack of redress for persons and communities subjected to the slave trade?
Certainly. Thank you very much, Lily. I'm very pleased with the thorough description that you've given of the proposal so that it's quite clear that there is a legal lacuna and that there are missing crimes in the Rome Statute. And I'm going to concentrate on slavery and the slave trade as a war crime under Article 8, as you described. Of course, when there is no enumerated provision, you cannot charge that exact conduct under its correct legal characterization. But how often are slavery and the slave trade part of an international armed conflict or an non-international armed conflict? is there really a factual gap in terms of what occurs? Well, I'd like to just remind you of 3 different wars where we see the presence of slavery and slave trading. Before we get to that war, let's go back to one of the Harold conventions in terms of humanitarian law, and that's the Lieber Code that comes out of the 1863 war between the states, the War of Succession, also known as the Civil War. If you go to the provisions of the Lieber Code, it specifically says that you cannot receive an enslaved person and keep them enslaved. And you cannot take an enslaved person and put them in another situation of enslavement. As a matter of fact, it's the 1863 Lieber Code that begins our recognition of customary law under war crimes that slavery and the slave trade are prohibited acts. One might say, well, that was a very peculiar situation as related to the United States during the Civil War, and of course during this war that actually moved to release or emancipate the slaves of an enemy state. But let's go to World War II. World War II, in many ways, in particularly with the Nazi socialist regime, was built upon a structure of what I would call slaveocracy. And that we know under the war crimes provision of the London Charter, there was a prohibition of deportation to slave labor. Why was that necessary? Because there were enslavement of persons in occupied territories who were conducting agricultural work that would be sent back to Germany. There was the enslavement of persons in German industrial sites. And many of these people came from outside of Germany. They were deported, i.e. slave traded into Germany and then enslaved. World War II was built upon structures of slave trading and enslavement and slave trading and enslavement. When we look over at the Tokyo judgment and you read it closely, and we look at how some of the prisoners of war and civilians were treated, they were enslaved persons, moved around to do illegal labor, slave labor. The bridge on the River Kwai. I hate to go back to a Hollywood reference, but there we are seeing slave trading and slave labor. When we look at the genocide in Cambodia, and we see the depopulation of the urban areas and the bringing of that population to work as enslaved persons for the Khmer Rouge, and then traded around, and at times forced to copulate, to produce or to breed children. We're looking really at facts of enslavement and slave trading and breeding of enslaved persons to create other enslaved persons for the Khmer Rouge. And then we can bring those issues up to current armed conflicts as described in Sierra Leone with child soldiers and the misnomer of bushwives. We can look at the conflict in Uganda and the relentless kidnapping of children, which is a euphemism for slave trading of children, enslaving those children as child soldiers or as bushwives or groomed to be bushwives, and then their relentless slave trading again. So with that context in mind, one would say, why under Article 8, this enormous list of war crimes, how could slavery and the slave trade be missing? There's a historical basis, factually, and there's a current factual. But we believe it was an oversight and looking at the preparatory works of the Rome Statute. But it's an oversight that has led to impunity, actual and real impunity, not just for the survivors, but also for the victims who are dead, because those acts could still be charged if the perpetrators are alive. So we have this relentless gap that not only doesn't recognize the harms that were endured, it refuses to characterize, to legally say its name, slavery and slave trading in international armed conflict and non-international armed conflict. And that is among the reasons that the Rome Statute needs to be amended, and particularly under Article 8. This is not a question of fragmentation. This is a question of really completion, to pick up the loose threads And I would like to just conclude to say that when we don't enumerate slavery and the slave trade as a war crime, we completely eliminate the ability to ever get reparations for that crime. So I would like to thank you for the opportunity to talk, but also to impart upon you is that this is not a frivolous exercise. This is among the most serious gaps, a structural gap in the Rome Statute that we have the ability to repair and therefore to prevent harms or to redress harms.
Thank you very much for these elaborations pertaining to war crimes specifically, and we are now moving over to Ms. Shaw. And it would be wonderful if you could talk us through, if we look more into practice, what is the actual impact of the lack of enumeration of the slave trade? And how does it affect not only your documentation process, but ultimately also access to justice for survivors?
Yeah, I'm really glad you ended on the point about reparations and what it means for survivors, because that's really, I think, where I'll pick up. So I work with an organization called Physicians for Human Rights, and we really work on bringing together science, medicine, and the law to document evidence of human rights atrocities, including sexual violence. And we do this through capacity development, medical legal documentation, and strengthening referral pathways. I say all of this, I hope you indulge me as I talk a little bit about the work that we do is because I think what we really see firsthand in our work across sectors and our work also with survivors of the very practical implications of the law of slave trade not being enumerated. So, my work is really focused specifically on sexualized violence and gender-related crimes and how to ensure survivors have the evidence they need to pursue accountability and justice, including specifically reparation. We work by training healthcare workers on how to strengthen the quality and preservation of forensic documentation of sexual violence, but also to avoid re-traumatization by repeated interviewing. So really getting it right the first time so that we don't have to keep going back. And also working across different sectors. So there's a shared understanding of what constitutes a sexualized form of violence, what kind of evidence is necessary, and what's relevant in terms of an adjudication process. So our work underscores time and again that reporting for sexual violence is hard. For those survivors who do come forward, who want their day in court, cases often fail because of lack of evidence or because of poor quality of evidence. And so, what we see is that there's just more broadly for sexualized forms of violence, really huge gaps in terms of the ability of the justice system to provide evidence, to understand the evidence, to document it, preserve it. And these barriers are really compounded when the acts have a linkage to slavery. So there's two major challenges that we specifically see for survivors in accessing justice when enslavement is at issue. The first, as several of my co-panelists have eloquently discussed in the amicus brief in the Young case, is the understanding of enslavement as an element of sexual slavery rather than sexual slavery as a form of enslavement and this really leads to increased barriers and access to justice for survivors. Often survivors' cases are charged as sexual slavery and therefore require showing that they were caused to engage in one or more acts of a sexual nature. But this framing really ignores that control over sexuality and reproduction are effective ways in which perpetrators exercise powers of ownership over all enslaved persons, regardless of whether the perpetrators commit sexual violence crimes, such as rape, in the course of the enslavement. Second, we also see that there's very specific barriers that arise where sexual slavery itself is recognized as a crime, but the acts that come before and after the period of enslavement itself are not criminalized, meaning that they can occur with impunity. So, how the slave trade is perpetrated is often gendered, and this can ultimately facilitate systematic sexual violence. For individuals who are taken for the purpose of enslavement, but ultimately do not end up in slavery, say they escape or for some other reason, they are also left without any remedy. And essentially, enslavement is just another example of an unnecessary burden or an improper framing that leads survivors to being denied justice, especially if they are actually enslaved. So in our work, we've seen two things really firsthand. The first is that clear legal frameworks lead to clear pathways to justice. Lack of understanding of what constitutes a violation of international criminal law contributes significantly to impunity. We see this generally with sexualized violence, right? There are many myths that sexual violence is only rape, or that men cannot survive, men cannot be survivors of sexual violence. This leads to really significant barriers. And it also leads very practically to the failure to document many forms of sexual violence. So then we don't have the evidence at all, right? To even be able to figure out, okay, how should it be charged? We don't have the evidence. And this really hinders access to justice for survivors who then lack the evidence necessary to have their cases pursued. This is all the more the case in circumstances where a crime isn't enumerated at all. So there's very specific challenges to documentation, as well as in knowledge among survivors of their rights to pursue a remedy. So in the context of slave trade, without this crime being enumerated, it makes it really difficult to collect the evidence of the crime itself, understanding how the survivor came to be enslaved, for example. So we often will see in medical records that there is some documentation that the person was in captivity, or even they'll use the phrase sexual slavery. But often the question of how did somebody end up in this situation is not asked, right? But it's not asked because people don't know that it should be asked. And also because, even when we do our trainings, we're asking very specifically, we train the physicians and others who do the documentation to not ask questions to relive trauma unless we know that there's a pathway forward, right? So we're not probing, we don't want to ask the questions unless we know that there's a way we can utilize the information. So, simply put, it's difficult to train and document for crimes that aren't enumerated. And if it were recognized, it'd be a lot, it'd be clearer for physicians and others to be able to understand in their interviewing process that they need to be asking the question of how did you end up here? What happened next? Did you leave? Did you go to another situation? And actually be able to ask those questions in that first interview. It's also really important because we train across the multi-sectoral pathway, so across law, then from medical to law enforcement, right, then to judges and police. And what we see, right, is that they also will there's often an overlooking of this kind of evidence, again, unless there's an understanding of this as a crime. And so there's another way in which the clearer the message, right, the clearer the pathway to justice. And finally, it's really difficult for survivors to come forward for sexual violence generally. But again, all the more challenging in a context where you may not even be aware that this could be considered a violation, or that this is an area where disclosing this information would have value working for it. So this is another space in which I think it's really important. The final point I really want to focus on is the other piece we see in our work as physicians, as doing intake and documentation of both physical but also mental health harms, resulting from sexualized violence, is also that the failure to recognize the violence that a survivor experiences can also really compound trauma and can limit prevention. So for some survivors, the abduction is the most violent part of the act. They may or may not actually end up experiencing sexualized violence, and they may not end up in enslavement, but they wouldn't be counted as victims in that case. And yet that is an incredibly traumatic experience in and of itself that currently is not recognized. It also really limits the availability of redress for these survivors, so then the access to mental health services or other forms of rehabilitation. And it also limits recognition of perpetrators and who did the wrong to a survivor, right? And the inability and the knowledge, right, that there's people out there that perpetrated this violence, and that will never be pursued. So I think that healing power and justice is something we really see in our work, and I think it's very important to bring this down to the human level. And really think about, okay, we're letting people walk around who experience really significant forms of violence, and yet this isn't recognized as a crime. And then I'll end on just one final note, which is also the real importance of establishing the slave trade as a separate prohibition and its role in prevention. And I think it is really important to be able to flag, even at those earliest stages, that we're starting to see these different these different acts occurring, and that actually that's the moment to act, not the moment when somebody's actually enslaved, right? But we're starting at the moment of hey, we need to be monitoring. These are part of our monitoring indicators that that slave trade is occurring. So I'll end there, but just a little bit of a reflection from that survivor and document perspective.
I think we could end there. Thank you so much for your intervention. And I just wanted to highlight two aspects that I think we've heard across the board of all speakers thus far. And that is really the fact that slave trade conduct or slave trade doesn't just occur before, but also during and after enslavement and or other already enumerated crimes. And the other aspect is really both the prevention and reparations aspect that we may not forget while we talk legal amendments. Last but definitely not least is Professor Jocelyn Getkin-Kessenbaum. And my question to you is, if we go back to the Rome Statute, we already heard specifically the legal gaps under war crimes. Could you talk us through the legal gaps under crimes against humanity, and also ideas and suggestions of how to fill these gaps?
Okay, sure, I can do that. Thank you, Lily, and thank you to all the panelists who have really set this up well to continue talking. So Professor Sellers talked about the historical reasoning, and that is mostly because when you look at the war crimes provisions, you see nothing. When you look at the crimes against humanity provision, you see enslavement. So I thought I would walk you through a little bit more the definitional language as well as the elements, so that you can see that, because a lot of times what response I get is, no, enslavement covers both slavery and the slave trade. And so my response was to go back to the language and to say, no, it actually is not there. So we'll go through that for a few minutes, and I hope to convince you that it isn't there. So if you look at Article 7(1)(c) of the Rome Statute, you'll see the definition of enslavement as a crime against humanity. And enslavement under the Rome Statute as a crime against humanity is defined as slavery. As you see the crime of slavery under the 1926 and the 1956 slavery conventions, which is the exercise of any or all of the powers attaching to the right of ownership over a person. And you see also some additional language about the exercise of such power in the course of trafficking in persons, in particular women and children. Cabin that part, we'll get back to that aspect of the definition. But if you look at the first half, you see that the definition of enslavement as a crime against humanity is mirroring the definition of slavery under the 1926 and 56 conventions. And that means that any charges of enslavement, for the purposes of proving those charges, you would have to prove that the perpetrator exercised powers of ownership over the person. Now I want to show you the definition of the slave trade. And I take the liberty of just changing a few words of the definition, because we've moved from calling individuals slaves to enslaved persons. So forgive me for the brackets, and maybe I didn't put them in there. Maybe this is okay, so we've already kind of massaged this, but know that this definition changes just those aspects of the 1926 and 56 conventions. So it's all acts involved in the capture, acquisition, or disposal of a person with the intent to reduce the person to slavery. All acts involved in the acquisition of an enslaved person with a view to selling or exchanging them. All acts of disposal by sale or exchange of a person acquired with a view to being sold or exchanged. And in general, every act of trade or transport in persons enslaved. So what do I mean when I say that the enslavement definition includes some acts of the slave trade, right? So if we look at the elements of crimes of Article 7(1)(c), you'll see that there is an elaboration of what the definition means of exercising powers of ownership. And in that aspect of the elements of crime, it does look like there are some acts of the slave trade in this definition. You'll see that the perpetrator exercises powers attaching to the right of ownership over a person, slavery, such as by purchasing, selling, lending, or bartering such a person, or controlling the sexual autonomy or sexual integrity of a person. We added that in. but from the 1926 convention, but you'll see that those particular acts are actus reus of the slave trade, but still the definition of the elements of crimes is still connected to the proof of exercise of powers of ownership over a person. And the slave trade from the 1926 and 56 conventions does not require that the individual exercise powers of ownership over a person. The real elements to the slave trade include the intent to bring a person into a situation or reduce a person to a situation of enslavement, to maintain that person in a situation of enslavement, or to dispose of a person in a situation of enslavement. There's nothing said under the slave trade criminal definition or elements of that crime that suggest that a slave trader need to exercise powers of ownership over a person. So we see that the enslavement crime under Crimes Against Humanity does not also include the slave trade as it is understood under customary international law. And that is specifically the intent to reduce a person, to maintain a person in, or to dispose of a person in a situation of enslavement. And as Pyle really eloquently alluded to, you can see that this has real implications in cases that involve enslavement or sexual slavery crimes under Crimes Against Humanity. There have been ICC judgments that include description of slave trade conduct, but that the ICC doesn't characterize as acts of the slave trade for the very reason that they cannot do it structurally. It's not included under the Crimes Against Humanity provision, but they are identifying the precursory conduct, right, of the slave trade as abductions, captures, kidnappings, giftings, transfers, exchanges. These entail how victims are reduced to and or maintained in the various situations of enslavement that sometimes are characterized and able to be prosecuted and punished, but only if the perpetrators, right now currently under the Rome Statute, only if the perpetrators are also enslaving through exercising powers of ownership can they actually be brought to any form of justice and for those victims to receive any form of compensation or redress. I think maybe I'll stop there because Lily has other questions for us and I want to make sure we have time for that.
Thank you so much. Before I give over to the audience, maybe there's one aspect we can discuss collectively, and that is really the fact that in July of this year, there was a declaration between the EU and CELAC states, and in that declaration, certain acknowledgements were made not only about historical slavery and the transatlantic slave trade, of course, but also the recognition that, in fact, the slave trade constitutes a crime against humanity. Could we maybe, among the panelists, comment on what this means for the Rome Statute amendments we are currently discussing? And after that, I give over for questions to the audience.
Thank you very much, Lily, for bringing this up. That shows that there are over 50 states between Latin America and Europe who recognize that the slave trade is a crime against humanity. That's almost a statement of opinio juris, a statement in the declaration almost of practice. They also understand and relate a historical basis of the slave trade and slavery, but are recognizing that that is a current crime against humanity. And this crime is absent from the Rome Statute. So I would almost say that's an admission of guilt.
Wonderful. I now turn over to the audience for any questions to any of the panelists. Please identify yourself by your name, and if you wish, institution, and also who the question is going to. Yes.
And I enjoyed your presentation. The question is, if I transfer my friend to another person, even it's not that, but it's slave trade. It's not a that act of transfer or abduction in itself, a manifestation of powers like power of property. So do we need a it's not a disposing of the because it's not a doing slave trade. Slave trade in itself of that power.
Well, I think what you're pointing to is in some ways how the drafters of the Crimes Against Humanity provision were envisioning the buying, the bartering, the selling as potentially exercise of powers of ownership. But what that does is it conflates slavery as a crime with the slave trade as a separate crime. And it really it diminishes really the systematic and structural nature of this crime, where you really do have several potential intermediaries before you get to a situation where a person is held in a situation of enslavement. And you really do have moving someone from one situation to another. And thus far, those situations are not characterized as enslavement as per all of the ICC judgments. And it really doesn't follow customary law that the buying and the selling would be part of the exercise of powers of ownership. You could have a slave trader who also engages in exercising powers of ownership in many different ways, but that isn't necessarily how these crimes are understood, especially when you look at the travaux préparatoires of the 1926 convention. It was really considered to be separate crimes, often done by actual separate perpetrators. And sometimes you have the same perpetrator doing both, engaging in both crimes, but it really conflates these crimes in a way that isn't true to the customary international law nature of the crimes. I don't know if Patty wants to add anything to that.
I would just say that under international criminal law, it's certainly very common to have cumulative charges. And so your slave owner might also be a slave trader. And that means that person could have two charges brought against them under crimes against humanity. It might be that your slave trader, let's make the analogy, is the bus driver who transports the ISIS slaves to another place, but certainly does not own those ISIS slaves. So we could have either situation.
Yes, the gentleman.
I have a question for the ambassador that you represent. I have already posed a question yesterday, but I think I attended a meeting of the working group of amendments this week at the United Nations, the parties, and they spent 35 of the 60 minutes they have to just discuss how everybody agrees to have a fourth judge concept in the rules of disciplinary evidence. I would have expected the Sierra Leone proposal to be on the table, but it was not. So I really urge and I ask Sierra Leone to really move forward with this. And I do believe that this will be also very important for the movement of other states to come with the reform on the crime of aggression jurisdictional regime, so that the two things can go hand in hand with ownership of both the 50 states that Patricia mentioned, plus the Africa group, which is more than 50, plus those that like Germany, Austria, Switzerland, Liechtenstein, Slovenia, and many others wants to reform the amendment, the crime of aggression jurisdiction. So really the moment is now. The Assembly of State Parties is going to be taking place in 6 weeks, and we are running the risk of another assembly only on election of judges, budget, and other things that are really not as important as this.
Thank you so very much. I like your proactive approach. May I kindly ask you to introduce yourself for the record and those who may not know you.
Thank you very much for your comment. Well noted. Because we are conscious of what you just mentioned, when discussions of the UN will take 30 minutes just maybe to agree on a word or a sentence, we are trying as best as possible to first develop a core group of like-minded states. So when we get to the working group and when we get to the negotiations, we'll not have these delays that we normally have in the discussions in the UN. So it's not like we're delaying the process, but we want to make sure when we get to the process, we are very active and it goes forward as soon as possible. So we've been engaging on the sidelines with like-minded states, and I'm pleased to inform that we have many states interested and really pushing also so that we can move forward with the time. So I think I can say right now off record or unofficially that by December in the meetings will not just be budgetary discussions or elections, we can actually have some discussion. I hope that answers it.
Curious, and maybe it's unfair to ask to speculate. If this had been enshrined with crime, would this also apply to something like the unpolicing system that exists in the United States or where there was, let's say, a different intention on the face, but in fact, people were acquired to perform labor even though they were technically part.
Well, I think it's quite clear under the US Constitution that that's the exception for labor that can almost be categorized as enslavement. And so to me, the convict leasing system, or just possibly the status of the person who is imprisoned, might be analogous to a status of enslavement. And I know that there are movements in several states now to remove that from at least the state constitutions and possibly the federal constitution. And I was in touch with a woman who was looking at that very issue in terms of the Nevada constitution to see could that be removed, because it is a retention or afterlife of the slavery legacy within the United States.
Any further questions? Yes.
Hi, I'm Patty Blum, and a colleague of Patty's at University of Oxford, Master's in International Rights Law. And I teach I'm trying to understand how this came about, this action. And I wanted to just ask whether the whole language of traffic, which is so ridiculous now, and it's applied in all kinds of human trafficking, applied in all kinds of contexts, whether the impetus to name certain things as trafficking somehow disguised the slavery, and how you see it, I especially the fact that so many people who are working on trafficking, to what extent should those groups and people who are involved in that start thinking more critically, I guess, about the use of trafficking in this context?
I'm so glad you asked that, because that was the second half of what I was supposed to be saying. You can tell how tired I am. This week has been really tough. I'm sorry, everyone. So can we go back a couple of slides to the definition of enslavement? You'll see that the definition of enslavement does include the words human trafficking, trafficking in persons, in particular women and children. And while there was a good intention behind including those words, I think it does in some ways conflate and confuse human trafficking with slavery and the slave trade. And I'll talk a little bit about why trafficking in persons, you can see it's not a separately enumerated provision under the Crimes Against Humanity section of the Rome Statute. And the reason for that is because it is not an international crime. It's a transnational crime. And naming it here is really elevating the issue of human trafficking as conduct that could be characterized as evidence of exercising powers of ownership over a person. But it really has led to, I think, some confusion. At the time of the drafting of the Rome Statute, it was exactly the same timing as the drafting of the Palermo Protocol, and the discussions were often being had about human trafficking in the same vein as the International Criminal Court and the international crimes. And so you do see a lot of discussion about needing to elevate, especially sexual and gender-based violence harms. And we think that is a big reason that trafficking in persons gets listed under the definition of enslavement without real legal meaning because of its different status under international law, but still important to look at particular conduct as potentially exercise of ownership over a person. And just thinking about status. So in many ways, it is very, it is problematic for redress for victims who may have been trafficked to not also look at whether or not they have been enslaved and or slave traded. Because of the normative status of slavery and the slave trade as an international crime without a statute of limitations, with the highest level of normative status as jus cogens, erga omnes, all of the things that come along with preemptory norms, it's important that we not look only to human trafficking. And factually, these various crimes, harms do overlap and are often happening coterminously. Patty was talking about being able to charge more than one crime. Well, we may have more than one avenue for redress, which may even include different courts or different, statutes, right? So for international criminal justice, we're looking at slavery and slave trade as the crimes, but there may also be domestic jurisdictions that could also prosecute and punish for trafficking crimes. So I think our message is all of these roads should be paved, but the trafficking road is not the one that leads to Rome. The slave trade is the proper crime in this situation.
Hi, my name is Sally. I go to Fort Hall. So actually, my question was on trafficking, but I guess kind of relates to slave trade. I guess it's more towards the Shaw. Sorry.
Yeah, no, you got it.
Yes, you're right. So when it comes to like prosecuting for or trying to seek protection for victims of the slave trade, does it like ever like go in the back of your mind the steps that might occur with others who were connected to them through the slave trade? Because oftentimes a lot of them people forward or say anything because of the risk of also having others and then also the person who technically the slave trade. So have you ever thought about that? And then maybe asking for protection from the slave trade?
Well, I may seek other, we have never actually at PHR tried to pursue a case around the slave trade, in part because it's not enumerated, so we can't. But, and actually I would say practically speaking, I was even, as I was preparing for this, kind of going back through the medical records that we have and, what have we found when we ask questions? And, I joined PHR about 2 years ago, so I was going back really like much older, predating me, and seeing a lot of questions actually about trafficking in particular, and realizing that I think part of why the answers that we were often getting was no, this person wasn't trafficked, we didn't have any patients that were trafficked, was in part because we're not defining these terms and we're not clarifying what we mean, and so then there's a lot of assumptions that come into, well, is it slave, these are all these are terms that mean different things to lay people too, or people that are not lawyers and not immersed in this. And so I think a lot of what I was reflecting on as I was going back through our research was also how these kind of misconceptions and the conflation between these terms and ambiguity leads to a lack of documentation. And I think that's been something that I've been thinking about a lot in terms of protection and in terms of ensuring that when we're thinking about legal strategies that we're thinking about victims and witnesses and also their safety and security, that's absolutely always first and foremost. I think that's like a core principle for those of us at least, I think, up here. And, I think, it is tricky, right? I think justice processes often are really looking at survivors as witnesses or survivors, but I think our work at PHR, for example, is really thinking about how we can work together with networks. This is part of why we really try to build multi-sectoral networks at the local level so that we can respond when survivors are facing potential risks or they're feeling hesitant about testifying. So there was a case in DRC that PHR was really deeply involved in about 40 young girls who had experienced sexual violence, and the families were really concerned about engaging the courtroom setting. And this was a mobile military court, and so we really had to put forward for the first time and persuade the court to accept different victim and witness protections, including the ability to testify, camera, to wear coverings, and so there's a whole range of different interventions that we've pursued in that context. But I think it's always, especially on the civil society side, I think always first and foremost at least for PHR. I'm sure others have noticed it.
Yeah, if I could just respond briefly, if this concern arises and slave trade and slavery were enumerated under the Rome Statute, then those witnesses or survivor victims would fall under the witness protection programs already established under their national criminal code. And they would also fall under the protection that might extend, when necessary, to family members. There are various means that occurs. And in addition to that, they would have the protection of contempt of court proceedings if someone was trying to interfere with them for their testimony. So there is a protection framework that applies to all witnesses, but in particular, it would apply to witnesses of enumerated crimes and those also who might qualify as official victims and have victim representation at the international community.
Just on the matter of abduction, I only disagree with the fact that there is a gap, because under the imprisonment line of the crimes of humanity, it's an imprisonment for other severe deprivation of physical liberty. So abduction is already captured when part of or instead of systematic attack against the population under this label. Nevertheless, that doesn't mean that the debate should not start. In my humble view, the war crime of slavery and the slave trade is a mistake made, it's an omission made by the Rome Conference, because the negotiators, I had the chance to talk to the main negotiator on crimes against humanity, thought that the concept of enslavement entailed an element of systematicity and large scale that was not to be found in an individual case of enslavement as a war crime. So that was deliberately omitted, and I think it's quite a serious oversight. Regarding crimes against humanity, in my humble view, it would be better to have an authentic interpretation, allowing all these elements to be reflected in some official document of the assembly, so to avoid that we don't have, the problem is that when we amend Article 6, 7, or 8, then it would enter into force only in cases in which both the state of nationality of the perpetrator and the state of the territory are both parties to the amendment. So we would run the risk of diluting the protection that enslavement or arbitrary imprisonment or other crimes against humanity already offer to all the victims, and allow only the slave trade to be confined to the case of, let's say, Germany against Austria, whatever, when you have the two countries colliding. And the final comment is, and I'm sorry, the joint investigative team on Ukraine has been invoked many times this day, various times. But there is another one called the joint investigative team on Libya, and it's already investigating these types of cases under the jurisdiction of the ICC. Hopefully the prosecutor will come up with some jurisprudence. These investigative jurisprudence will enlighten about how trafficking and enslavement could be seen as overlapping, at least in those.
I briefly respond, Donato. You're wonderful. You're absolutely great in all the points. So for the deprivation of liberty under imprisonment, that's the deprivation of liberty where you do not have to exercise the power of ownership, whereas deprivation of liberty under the enslavement definition is a type of example of where you be exercising powers of ownership. And I agree with you, there might be a two-tiered jurisdiction between the different states who have to ratify. But that means that we have to advocate for consensus and everyone moving forward to ratify immediately on both bases, so that we have a very small time lag gap. But that happens with every amendment. And I think in terms of Libya, there has already been a public pronouncement by Prosecutor Khan that says that we do not have trafficking under our jurisdiction. But certainly this is part of the complementarity that national jurisdictions might use, in addition to if they have national provisions for slavery and slave trade, but that we should be looking at enslavement. So excellent.
Okay, if there are no more further questions, I will just give a brief round to all panelists. Any thoughts on either next steps or aspects you would like to highlight to give the audience on their way, hopefully home or to dinner or to a nice gathering, starting with you, Ms.
Thank you, Moderator. Just to add more points on what you just mentioned, the commenter just your point about one state rectifying or acceding to the amendment and another and then diluting the application of it. That's why we are pushing very hard to have as much consensus among states, even during the negotiations at the UN, both on informal consultations and when we get to work with the working group on amendment. Because we've seen this situation even when we were negotiating the BBNJ, we try as best as possible to have as much intersectional discussions and official discussions and bilateral engagement. And we're using the African group, like you mentioned, it's comprised of 54 countries. That's a big voice to push this amendment. And then we're hoping that at the time when we get it adopted, we'll not have the problem of one state ratifying or acceding it and diluting its application. So I think that's gonna work for us, I hope. Thank you.
I think my final word would be just to say that we all descend from multiple situations at time of enslavement and other forms of slavery. And in some of the work that we've done, we've been looking at what's called the Barbary pirate slavery, where over 1.5 million Europeans were enslaved between the 1600s and 1900s. It's been almost erased from our memory. And therefore erased from actual factual situations that we could use today to understand slavery conduct. And particularly slavery conduct that's happening in Libya is very much related to the slavery institutions that occurred during the Barbary pirates or enslavement, and that system of using tribute or asking for ransom in order to release the slaves. So I would say that we're beginning to open up a new world of our own truth as a world community.
I think I'm leaving with a lot of food for thought from other panelists as well, but I think one thing I keep coming back to as well is sort of the opening point from Lily to really centering intersectionality and thinking about the ways in which enumeration of the slave trade also links to, you know, other dimensions and groups that are particularly targeted for control and ownership. And so that's just a point I'm sitting with and reflecting on. So thinking about the cases that have also been shared. So maybe something for us to all think through as well.
And I'll leave you with some hopeful news that the slave trade can be brought into the Rome Statute crimes currently, because it is a violation of prohibition under international law and a violation of human rights. And so under the persecution crime, the severe deprivation of fundamental human rights could include also the slave trade. And that's one place where it's not missing in action, but we have lots of places where we need to make sure it's there so we can have full redress for victim survivors.
Thank you so very much to our distinguished panelists for really talking us through the legal lacuna in the Rome Statute, and then Sierra Leone for their really proactive, but also very mindful proposal and approach to this very critical Rome Statute amendment that both speaks to the history of humanity, but also its present form. from the organizers, I should let you know that the CLE code for this panel is Gazelle, Gazelle. And I should remind you to enter this on your CLE form found at the end of the program that you got from the registration desk. And I thank you all that you attended this conversation on a Friday afternoon and early evening. And I hope you follow these developments as they will most certainly progress within the next year. Thank you so much.